Hey folks, welcome to Roll of Law. So after Wizards of the Coast kind of screwed up and had a giant debacle with the OGL revisions, the Orc license was proposed as an alternate solution. Now, I've been critical of the Orc license, and I remain critical of the Orc license, in particular because of its mandatory share-alike nature and how much it makes people give away. In fact, a lot of people who use the Orc license may not realize just how much they're giving away, just how much they're letting other people do things with their work that they may not approve of. And I think that is a potential recipe for hurt feelings and for creators to get hurt by the Orc license. So I've been critical of that. Another thing I have critiqued is that the Orc license has been billed as kind of a simpler option where you don't need a lawyer. And I don't think that's true. The Orc license can be deceptively complicated. So what I've been proposing is an alternate license, a license that isn't mandatory share-alike, but that facilitates sharing where you want to. And so I've been calling that the Elf license because elves and orcs don't get along, and because people say I look like an elf. So it's not an acronym, it's just kind of a joke. But at least a joke name. The license itself is intended to be serious. It's intended to be useful to people. Now, I've got a draft here. It's not the final draft, but I wanted to go through it with you guys. If anybody has criticisms or comments, I'd love to see them in the comment section below because this is a work in progress. I want to make sure that we get this right. But I went through the Orc license kind of section by section, and I want to do the same thing with the Elf license with you guys so that people get an idea of what I'm thinking here. All right. So it starts off, and again, this is our draft here, Elf license. This license, hereafter referred to as the Elf license, grants the right to use licensed content subject to the terms and conditions set forth and referenced as follows. Now, I'm just going to note, you will probably notice that some portions of this seem familiar if you've read the Orc license. And that's because Azora Law and Paizo said, hey, feel free to copy the Orc license. I take them at their word, and I think it's useful. So I do owe them a debt of gratitude for some of the building blocks of the Elf license, and it would have been a lot more work absent their contributions. So thank you. All right, so definitions. Product identity. And product identity means trademarks, trade dress, and non-functional and creative expressions that are not essential to or can be varied without altering the ideas or methods of expression of a game. So trademarks are things like, Wizards of the Coast is a trademark. Typically, company names might be trademarked, that sort of thing. Trade dress is particular ways you package a product such that people recognize it as yours. They might not be trademarked, but they might be distinctive so that people can recognize your products as yours. And there is intellectual property protection in those to prevent people from just copying that stuff. So that are not essential to or can be varied without altering. This is just, we're trying to get at the concepts here of this product identity, of stuff that basically says, this game is my game. If I am working on a, my friend David Prototopics is working on something Campfire Kingdoms. And so the name Campfire Kingdoms is probably something he wants to protect. So including works of visual art, music and sound design, and clearly expressed and sufficiently delineated characters, character organizations, dialogue, settings, locations, worlds, plots, or storylines, including proper nouns and the adjectives, names, and titles derived from proper nouns. So this means things like, if you're Wizards of the Coast, Driz de Werden is a character that is a sufficiently delineated character. You can't write stuff for that if you don't have a license. Character organizations, so things like the Red Wizards of Thay. Can't write for that unless you have permission. All of these things are kind of the flavor of a game. And the reason why this is being specifically defined is that the elf sets aside product identity unless you say otherwise. And I'll talk a little bit about why I think that's a good thing to do. So the term product identity shall in no event include elements that are the exclusive property of one or more third parties or that are in the public domain, i.e. you can't protect stuff that isn't yours, and you can't protect stuff that belongs to everybody because, again, that's not yours. So ELF licensed content means 1, any material that has been expressly designated by yourself or a previous licensor as constituting ELF licensed content. So ELF licensed content is stuff that somebody has chosen to give away. There are no provisions here that require share alike. In order for something to become ELF licensed content, someone has to have chosen to make it ELF licensed content. Now, the criticism people will have is, what if somebody designates none of their new material as ELF licensed content? And in that case, it's not licensed to you. The ELF license is not one that controls people downstream. It doesn't tell other people what to do, and that might not be what you want. You might be looking for a license that does tell them what to do, in which case this is the wrong license. The ELF license is particularly intended for people who want to be hands-off with people who use their work, but to also facilitate and enable those people to share things. So you must have the rights to content to designate new content as ELF licensed content, i.e. you can't declare something ELF if it's not yours. Kinda should go without saying, but we still say it anyway. So the other provision here is ELF licensed content specifically excludes product identity unless you specify otherwise. So if you say that ELF licensed content includes pages 30 to 75, any product identity that's contained in those pages is not ELF licensed content unless you specifically designate it as such. And the reason why is because there are additional dangers associated with giving away product identity, as opposed to giving away descriptions of mechanics. So for example, if I give away and let somebody use a new spell, Horton's Flatulence or something, the specific text of that spell, you're probably not going to be too worried if somebody adapts it in some way. But there are real issues if you give away a character and then somebody else starts adapting it and they own those adaptations and that you don't have control over them. This is a problem with the orc. If you choose to designate that kind of content under the orc, this is still a problem. It is also something that I recognize as a potential issue under the elf, which is why it is specially protected, why it has that additional layer of choice. I don't want anybody to pull this trigger without knowing that they're doing so and without doing so intentionally. That's what this is intended to accomplish. All right. Original elf content means content that you have licensed under the elf license. That is a subset of the larger set of elf content, and therefore any content that is original elf content is also elf licensed content. I.e., this refers to the stuff that you are using from someone else. Somebody else designated this work as elf content. You're using it as original elf content, but it's part of the larger pool of stuff people can use. Designated elf content means new or adapted content that you have designated as elf licensed content to contribute to the pool of elf licensed content, and which may be licensed by others as original elf content. This is a subset of the larger set of elf licensed content, and therefore any content that is designated elf content is also licensed elf content. I'm going to just amend that right here. We're just going to change up our terms. So we've got a new revision already. Elf licensed content. We want to keep our terms consistent, and there we go. So designated elf content is basically all of the stuff that you as a creator are giving to the next round of creators. And that can be the changes that you have made to other content. So for example, if somebody has a new character class and you modify it, you make it better, you may well choose to give those modifications on to the next people. or it might be completely new content. Either of those are fine. So copyright and similar rights means copyright and/or similar rights closely related to copyright, including without limitation, performance, broadcast, sound recording, and sui generis database rights without regard to how the rights are labeled or categorized. In no event shall copyright and similar rights include trademark or patent rights. So basically, we're just trying to define what we're talking about. And again, the license does not intend to step on your trademarks or your patents if you happen to have any, which is uncommon, but not impossible. Effective technological measures means those measures that, in the absence of proper authority, may not be circumvented under laws fulfilling obligations under Article 11 of the WIPO Contract Treaty adopted on December 20th, 1996, and/or similar international agreements. Basically, this is digital rights management technologies. There are protections for those in copyright law in many countries, and so this basically is going to allow breaking of those for certain purposes. License rights means the rights granted to you subject to the terms and conditions of this ELF license, which are limited to all copyright and similar rights that apply to your use of the ELF content, and that the licensor has authority to license. Again, they can't give you powers that they don't have. Licensor means any individual or entity granting rights under this ELF license. Fairly obvious. A licensor is a person giving a license. Sui generis database rights means rights other than copyright resulting from Directive 96/9/EC of the European Parliament and of the Council of 11 March 1996 on the legal protection of databases as amended and/or succeeded, as well as other essentially equivalent rights anywhere in the world. Databases is complicated, but this is intended not to run afoul of those rights as well. Term means the term of the copyright and similar rights licensed herein, which may vary depending on where you live. Use or used means to use material by any means or process that requires permission under the licensed rights. If it doesn't require permission, then you don't need a license in the first place. Such as production, reproduction, creation of derivative works, public display, public performance, distribution, dissemination, communication or importation, and to make available to the public, including in ways that members of the public may access the material from a place and at a time individually chosen by them. And you or your means the individual or entity exercising rights granted under this ELF license. Okay, so now we're getting on to grants and limitations. What does this actually do? So primary grant to you, what are we giving you? All right, so subject to the terms and conditions of this ELF license, for the term, licensor hereby grants you a worldwide, royalty-free, non-exclusive, irrevocable license. So worldwide is everywhere on the planet. Royalty-free is you don't have to pay for each time you use something. Non-exclusive means if you use a particular bit of ELF content, that doesn't stop anyone else from using it. Everyone can do it. This is intended to create a pool of stuff that has been willingly given away, willingly shared with the public. Irrevocable means that there's no backsies. You can't say, ooh, sorry, I don't want to do that anymore. I want to take that permission away from you. And that's important because if you start writing a bunch of stuff using ELF content, you don't want the rug to be pulled out from under you and then you're stuck. To exercise license rights in the ELF license content, to use the ELF license content in whole or in part. Licensor hereby authorizes you to exercise the license rights in all media and formats, whether now known or hereafter created, i.e., if we come up with like direct brain implantation and you want to make a role-playing game for it, you could use ELF content. It's, just so that this is future-proof. And to make technical modifications necessary to do so, i.e. if you need to translate a particular set of rules into like a video game format, that's fine. Licensor hereby waives and/or agrees not to assert any rights or authority to forbid you from making technical modifications necessary to exercise the license rights, including technical modifications necessary to circumvent effective technological measures, i.e. if you are giving away content under ELF, but you also DRM it, people can still access that content. You are granted the right to sublicense the ELF content on exactly the same terms as in this agreement. Now, this is not in the ORC license, and this is really to address what I think is a very niche possibility. I'm not going to get into the weeds on this one because it's a very niche problem, but basically this just says you can give this content out under a further license so long as it's the same license, but you can't license it on other terms. You can't, because at that point it's not your content, right? So, grant of ELF content by you. You hereby grant to any recipient of the work containing the ELF content a license to use the original ELF license content, i.e. you're giving people permission to use the stuff you used, and any ELF license content specifically designated by you under the terms and conditions of this agreement as designated ELF content. This means that it has to be voluntary. There is no provision here that identifies certain kinds of content other than the stuff you got from someone else as something that you must share down the line. And the stuff you got from someone else, well, they already shared it. It's already in the public. That doesn't cost you anything. It doesn't twist your arm. It doesn't break your leg. It just, that's already there. So that's not forcing you to do anything. That's just respecting the fact that somebody else already gave that away. You may not offer or impose any additional or different terms or conditions on the ELF license content that you have licensed. I.e., if you can't change the terms of the stuff somebody else gave you, or apply any effective technological measures to the original ELF content, if doing so restricts exercise of the licensed rights to any recipient of the original or of the ELF license contents, i.e., you have to let people have access to the stuff that's being given away, whether that's the stuff that was already given away or the stuff you choose to. For clarity, it will not be a breach of this agreement to apply effective technological measures to the content if the content is also provided in the same work or the same distribution without effective technological measures. And this is specifically, I was thinking of video games here. Although it doesn't just apply to video games, it might apply to video content or virtual reality content. But let's say you're making a game and you don't want people to pirate your game, but you're basing it off of an ELF licensed work. And so you want to give away, or you want to be able to put DRM on your game so that people don't pirate your game. You can do that. You're allowed, just so long as you also throw in the same package, with the same download, just a plain text copy. It makes it easy. It's easy to comply with this. This is intended to be something that gives you more flexibility here. So there are circumstances where the ELF license kind of respects that you might need to use effective technological measures, but you still have to give away the stuff that is given away in a way that people can actually use it. You can't do a fake out game on that. That also prevents people from locking down the original ELF content that they used. If it's in there, other people using your work have to be able to use it as well. So, database rights. Where the license rights include sui generis database rights that apply to your use of the ELF license content, this ELF license grants you the right to extract, reuse, reproduce, and use all or a substantial portion of the contents of the database. And if you include all or a substantial portion of the database contents in a database in which you have sui generis database rights, then the database in which you have sui generis database rights, but not its individual contents, shall constitute ELF licensed content. So again, this is to handle database issues, which is complicated, but that's kind of the idea. This will not be something that affects most people, but it's in there in case it does affect you. So limitations. Nothing in this ELF license constitutes or may be construed as permission to assert or imply that you are or that your use of the ELF license content is connected with or sponsored, endorsed, or granted official status by the licensor or others designated to receive attribution hereunder. So what does that mean? Let's say I make a new game and I put it under the ELF license. It's available, you know, very substantial portions of it are available. You cannot say that your work is endorsed by Ian Runkle. That's not allowed. Unless you get specific permission, like if you call me and I say, hey, yeah, I endorse you, then you can. But you're not given that by default. And that's because you're not going to have control over what people do with the stuff you give away. And some of those people may be people you disagree with. They may make games you don't like, that you, in fact, object to morally. And so it's good if you're not being flagged as officially condoning it. So moral rights, such as the right of integrity, are not licensed under this ELF license, nor are publicity, privacy, and/or other similar personality rights. However, to the extent possible, the licensor waives and/or agrees not to assert any such rights held by the licensor to the limited extent necessary to allow you to exercise the license rights, but not otherwise. I.e., you're not going to pursue moral rights and publicity rights and so forth with respect to this content, but it's not a general waiver. To the extent possible, the licensor waives any right to collect royalties from you for the exercise of the license rights and use of the ELF license content. And there we go. We're just going to tidy that up. I'm doing a little bit of proofreading as we go because this is the way it goes. I've been doing a lot of iterations of this. The licensor waives any right to collect royalties from you for the exercise of the license rights and use of the ELF license content, whether directly or through a collecting society under any voluntary or waivable statutory or compulsory licensing scheme. I.e., there are in some places like boards that will collect money on your behalf. And this says, no, don't. This is a royalty-free thing. People can use it without paying those, to the extent that it's possible to waive it. Now, you're going to have to check. I've said... one of the criticisms is the suggestion that the ORC license is sort of lawyer-free. And I'm never going to recommend that you use any license without talking to somebody to better understand your rights. And that's not me, right? This is not legal advice. I'm explaining this, but I'm not giving you specific legal advice as to whether or not this works for you or will cause you problems with your specific application of it. So I will always say, check with a lawyer. It's important. So, and spending a couple grand on a lawyer can save you huge money later. Required notice. The grant of this ELF license to you is expressly conditioned on you including the notice statements described in subsections A to C below in a reasonable manner based on medium, means, and context in which you use the ELF content. So, I said that the ELF license doesn't require a whole lot from you. This is what it requires. It requires you to include a statement. So ELF notice. The following statement designating the location and terms of this ELF license. So this product is licensed under the ELF license 1.0. We're not at 1.0, we're at 0.12 here, but located at location to be determined and others. All warranties are disclaimed as set forth herein. And attribution notice. A statement based on reasonable, good faith efforts that identifies each licensor or creator of the ELF license content you used and any others designated to receive attribution, including all upstream licensors of ELF content upon which work is based or derived from, i.e., you have to do attribution and reasonable, good faith efforts. We recognize that sometimes it might not be possible, but you got to make proper efforts. For the avoidance of doubt, both licensor and all parties similarly credited under licensor's attribution notice should be included in your attribution notice, unless otherwise reasonably indicated by such parties. Why might they? Because you might say, listen, you don't have to attribute me. That's allowed. And then a statement indicating how you wish to be reasonably credited with respect to the adapted ELF content licensed by you under this ELF license, including by pseudonym or anonymously if designated. So how do you want to be credited? For people who are doing this attribution thing, I might want to be credited as Ian Runkle, or I might want to be credited as Role of Law. Maybe Ian Runkle hyphen role of law, right? All of these are possible. Or I could say, you know what? I only want to be credited anonymously. That's fine. Now, if your preferred attribution is a graphic, image, sound, virtual reality content, video content, or any other form of content beyond pure text, you must include a pure text version of your attribution as well. Why do I put this? Well, because some people want their attribution to be some graphic, and a graphic might not work for every where everything goes. Maybe your original work is an audiobook, and so the attribution that you specify is a sound. Maybe it's, a musical jingle that describes your company. Well, you still have to include a pure text version, because if somebody is making a text version of something, then that has to be there. This is also for disability accommodation. You may attribute any licensor with the pure text version of the attribution or an audio or visual rendition of that text at your discretion, i.e., you can use the pure text attribution. It is a good thing to attribute with their graphic or whatever else if they want, but it's not going to be a breach if you use the pure text version. If a licensor fails to include a pure text version of their preferred attribution, you may attribute to them using a description of their preferred attribution. So this is basically, if you don't do the pure text thing, if all you have is a virtual reality image as your attribution, and I'm writing a book, so I can't include a virtual reality whatever, then instead I can just kind of try to describe it as best I can. So this is an encouragement to include the pure text version, because your description and my description may differ, but it is intended, once again, to facilitate this being available in the most ways possible. You may adapt any attribution as reasonably required to provide accommodation to disabled individuals. So, if your attribution is a graphic, somebody can put it in Braille, and that's not a breach. If if it's just text in writing, they can make it into audio, not a breach. All of these things are not a breach. I wanted to facilitate that to the greatest extent possible, because disabled people are part of the community as well. It just makes sense. So next is a statement indicating which, if any, elements of product identity have been licensed by you or other licensors as original ELF content or designated ELF content, i.e., what stuff can somebody downstream use? This is a roadmap to allow them to know what things they're allowed to make use of down the road. If this statement is omitted, it is considered a statement that no such elements are further licensed. So what that means is that there's no designated ELF content. If you don't include such a statement, basically you're saying, I'm not giving you anything. And that's fine. As I said, this is not a grabby license. There is no requirement that you share anything down the road. It's a good thing. I encourage people to do so, but I'm not going to force anybody. That's and the ELF license isn't going to force anybody. So de-attribution. If you receive, and it's scrolling too fast here. If you receive a request from a licensor to remove the attribution to that licensor from your work, you must reasonably comply with that request. For clarity, reasonable compliance does not require the destruction of any already printed physical copies, nor for anyone to cease distribution of any already printed physical copies. So why might you de-attribute something? Well, let's say somebody publishes something that you consider politically offensive, right? They make a game that is all about kicking babies, and you do not agree with kicking babies, because why would you? So they're allowed to use your content. You cannot stop them. There is no moral clause in this once you have given it away. But what you can do is you can say, take my name off your work. And so then they have to put it out with, without your name on it. And they can still make the works. However, if they've already printed 100,000 copies, they don't have to pulp 100,000 copies. And they can still sell those. They can still distribute those. De-attribution is a going forward step, not a go back in time step. And that's because otherwise this license would be too dangerous to use. You would never want to use this license if that was retroactive, because, you know, you print however many copies and they say, you know, de-attribute them, and now you've got to destroy them. Similarly, there is re-attribution. If you receive a request from a licensor to change the attribution to that licensor in your work, you must reasonably comply with that request and adapt the attribution to the new name, pseudonym, or anonymous as the case may be. For clarity, reasonable compliance does not require the destruction of any already printed physical copies, nor for anyone to cease distribution of any already printed physical copies. Same reasons on the no destruction thing. Why might you want to reattribute your work? Well, maybe you changed your name. Maybe you incorporated. Maybe you started out just like as Ian Runkle, but it turns out nobody recognizes Ian Runkle. They recognize Roll of Law. And so all of my games are being put out as Roll of Law. I'm like, please just adapt this to Roll of Law. Makes sense, right? You may want to walk away from a particular work in the past. All of these are reasons why you might want to reattribute or de-attribute. And I've got a typo here, so I'm just going to correct that while we're here. Attribution valid notwithstanding variation. So long as the above elements in 3A and 3B are included, an attribution intended to comply with the requirements of another license will be deemed to also comply with this license. Why is this here? Well, the ORC license, the OGL, various other licenses are very unfriendly to other licenses. They basically say you can't combine this with other licenses. And I don't like that, because we end up with this possibility of getting all of these licenses that just can't cooperate. And what use is there of putting all of this material out there for everyone to use if you can't use all of it? And if you have to be very careful as to like, oh, I want to include this and this, but they're under different licenses and they just can't mix. I think that's a negative outcome. And so as much as I dislike the ORC, this is intended in part to allow you to use ELF material in an ORC licensed work. And I will note the reverse is not really true. So, you know, this is intended to cooperate with other licenses as much as possible, to allow that mixing, to allow ELF content to be used as widely as possible, because again, you're not putting a leash on it. You're not putting handcuffs on it as it goes out the door. And so people can do whatever with it. That's the idea. Sample notice. So by way of example notice, example only, the following notice would comply with the requirements of this ELF license. So ELF notice, this product is licensed under the ELF license located at to be determined. All warranties are disclaimed as set forth therein. This product is compatible with and based on the following ELF content: title of work, copyright notice, author credit information, title of additional work, copyright notice, author credit information, etc. If you use our designated ELF content, please also credit us as follows: title of this work, copyright notice, your author credit information, right? Just telling the next person how to credit you. Product identity. Product identity elements in this product include, but may not be limited to, Hamlet, the Rotten State of Denmark, the Order of Rosencrantz, and Guildenstern. So these are just things you are, but keep in mind, if you don't designate stuff as product identity, but it still fits the definition, it is still product identity. So this is intended to be helpful, but it's not binding. So still consult with your lawyer, right? I said lawyers are important here. Expressly designated ELF content. So the following elements are owned by the licensor and are offered to all recipients as designated ELF content. This is the stuff you're giving on to future users. So pages 3 to 6, the entire chapter titled Bestiary, the content on page 17, beginning with and including the heading Count Trotter, and concluding before and not including the heading Baron Wheatley. This content specifically includes product identity as designated ELF content. So that's an example of, I want to give away these characters and this stuff. There's other ways you could do it. And so an example might be all content on a green background. in this work is designated elf content. That would be a very visually convenient way for somebody to tell, but it might annoy the reader. So these are just options, right? So this is an example. It is not the only way to do it, but it is an example of a complying notice. So warranty and limitation of liability. Licensor licenses the ELF content as is and as available and makes no representations or warranties of any kind concerning the ELF content, whether express, implied, statutory, or other. Why is this in here? This is the don't sue anybody clauses. This includes, without limitation, warranties of title, merchantability, fitness for a particular purpose, non-infringement, absence of latent or other defects, accuracy, or the presence or absence of errors, whether or not known or discoverable. Again, we're saying you can't sue over using my material. Where disclaimers of warranties are not allowed in full or in part, some countries don't allow this, this disclaimer may not apply to you. To the extent possible, in no event will the licensor be liable to you on any legal theory, including without limitation, negligence, or otherwise for any direct, special, indirect, incidental, consequential, punitive, exemplary, or other losses, costs, expenses, or damages arising out of this ELF license or use of the ELF content, even if the licensor has been advised of the possibility of such losses, costs, expenses, or damages. Again, this is intended to basically say nobody gets to sue. Where a limitation of liability is not allowed in full or in part, this limitation may not apply to you. The disclaimer of warranties and limitation of liability provided above shall be interpreted in a manner that, to the extent possible, most closely approximates an absolute disclaimer and waiver of all liability. All right. Other terms and conditions. And I know this is a long video, but we're going to go through everything here. That's the point. So termination and remedies. Your license to use the ELF license content will terminate automatically if you fail to comply with the terms and conditions of this ELF license. I'm adding an S here. I'm going to put this up online as well. There's going to be a version linked in the description below, so you can check it out. Your license will be reinstated, effective as of the date of the termination, if you cure such violation on a going forward basis, without the obligation to destroy inventory on hand, within 60 days of your discovery of the violation, or if licensor waives such violation in writing. So if you fail to comply, they can let you know, and you've got a period to get back into compliance before you're just outside the license. No such termination shall affect, limit, or disrupt the rights of any licensor or downstream licensee of any ELF license content under any ELF license, i.e., just because you breach doesn't affect the person who's using your content. They still get to use it. Only the licensor and licensor's upstream licensors under this ELF license, which you are deemed to be in privity herewith, may bring enforcement action against you hereunder. This limits how many people can sue you. This constitutes a limitation on licensor remedies with respect to the license grant in the ELF license content hereunder. However, this ELF license neither limits licensor's remedies in any way with respect to the licensor's product identity, nor does it limit licensor's right to offer the ELF license content or any other content under separate terms and conditions. So let's say I make a game and I license a bunch of stuff out under ELF content, but then somebody says, hey, I want to have a custom license with you. I can still license it to them, and that's fine. They have a license under a different set of rules than you do. That's allowed. Modifications. This ELF license may not be amended, superseded, modified, updated, repealed, revoked, or deauthorized. So this version of the ELF license, and I'm not promising that there won't be new versions, because there may be needs to improve things. And it might be that ELF 2.0 is better than ELF 1.0. If that happens, there will be ELF 2.0. But any of the work that is licensed under ELF 1.0 will remain licensed under 1.0 forever. There is no way to change that. So neither you nor licensor may modify the terms of this ELF license. However, you may enter into a separate agreement of your own making, provided such agreement does not seek to modify the terms hereof. You can make side deals. That's fine. With any content you own that isn't ELF licensed, right? Because if you're only getting it through the ELF license, then that's not going to be available. This ELF license does not and shall not be interpreted to reduce, limit, restrict, or impose conditions on any use of the ELF content that could lawfully be made without permission under this ELF license. This applies in particular to like mechanics, because some elements of the description of mechanics may be protectable. However, many elements will not be protectable, and using the ELF license doesn't prevent you from doing that. Wizards of the Coast's OGL restricted you from even indicating compatibility with their games, which the ELF license doesn't do that. It doesn't take any of those rights away from you. To its credit, the Orc license doesn't either. That's not one of my criticisms of the Orc license. So, to the extent possible, if any provision of this ELF license is deemed unenforceable, it shall be automatically reformed to the minimum extent necessary to make it enforceable, i.e. fix it if it's broken. And if the provision cannot be reformed, it shall be severed from this ELF license without affecting the enforceability of the remaining terms and conditions. If there's a bad term, that bad term goes, but the rest of the license stays. Otherwise, if you don't include a clause like this, if there's a bad term, then the whole license goes, and that would be a very destructive thing. We don't want that, because people downstream might be left twisting in the wind in those circumstances. That would be bad. So, no term or condition of this ELF license will be waived, and no failure to comply consented to unless expressly agreed to by the licensor. Nothing in this ELF license constitutes or may be interpreted as a limitation upon or waiver of any privileges and immunities that apply to the licensor or you, including from the legal processes of any jurisdiction or authority. Probably doesn't apply to you, but if it does, this is the sort of stuff that I would say talk to a lawyer if you think it applies to you. Construction. This license is published simultaneously with an FAQ document. We'll review the FAQ in another video, because this one's getting real long. The FAQ document is intended to provide a general indication of the draft's intentions in interpreting the ELF license, and in the event of a dispute, the FAQ is intended to be admissible to and used by any adjudicating body for any such purpose, i.e., the FAQ is not part of the agreement. However, it is something to help if there's something where the court is saying, we don't understand what this means. If the FAQ would help them understand, they can use it for that purpose. So, yeah. The ELF license may be translated into other languages. You and licensor agree that if there's any conflict between the ELF license, the FAQ, and any such translated version, the English ELF license shall control. So even though you translate this into French or German or Japanese or, one of an indigenous language or anything like that, the English language version is the one that is the legally significant version, if that makes sense. The current version, 1.0 of the ELF FAQ, is only intended to be admissible to explain the current version of the ELF license, 1.0, and no subsequent FAQ shall be admissible to explain this version, i.e., there might be new versions that come out, and those new versions will have a new FAQ. But anything that is clarified in the new FAQ does not retroactively affect this. That's just to give you some certainty in the use of this document. So, that's the end of the license. As mentioned, I did rely a fair bit on, Azora Law and Paizo for some of the building blocks, but the fundamental difference here is that making a license that doesn't require the same things from people downstream. It isn't a license that that seeks to demand those things from other users. So let me know in the comments what you think. If you've got comments, if you've got criticism, if you think this sucks, let me know. Because if it sucks, I want to know that before I sort of say, hey, this is a final version. Because I would very much like to know comments. That's just kind of my thinking here. So let me know, and that's kind of my explanation of the ELF license. If you have any questions after I went through that, let me know as well. I'll try to answer them as best I can, possibly in a future video, but yeah. So that's, I guess, the first look on this channel at the ELF license. I hope it generates some interest, but ultimately, if it doesn't, that's it. I will address one criticism people have made, which is people have said, how are you making money on this? What is your cut? And my cut is nothing. I do not have a path to make money on the ELF license. There is no royalty for using the ELF license. There is nothing. If you use the ELF license, you're not required to credit me. You're not anything. I just want it to exist and to be helpful, and I hope it gets used. That's the only thing I get out of this, is that I hope it helps some people, out. So anyway, that's it for now. See you next time.